Welcome to Bad Law, Worst Facts. I'm your host, Michael Tackler. Today I have Tod Clement on. He's going to talk to us today about distracted driving. Todd, how are you doing today?
I'm awesome. Thanks for having me.
Todd, you have done distracted driving, I would say speeches, but they're really speeches/conversations, not only for TTLA and DTLA, because you're in Dallas, a bunch of places, right? A lot of organizations. Tell me about that.
So when I first started doing this in 2010, pretty much distracted driving was in its infancy. I ended up getting in with a bunch of the leading scientists in the country because of a case, obviously. And they said, wow, you're fairly passionate about this. Do you want to go with us and speak on the road for this for safety seminars, particularly for National Safety Council, for NHTSA, we had 2 distracted driving seminars put on by the Texas Department of Transportation here in Texas. And each and every time they would ask me, because what we did is we had a really cool group of people. We started out with a scientist who generally was Paul Atchley out of the now University of Central Florida, then University of Kansas, or Dave Strayer out of the University of Utah. They would talk about the scientific reasons why this stuff is very, very dangerous, why distracted driving is incredibly dangerous. Then they would bring me along, and I would basically be the stick. I would tell industry, this is what's going to happen to you if you don't fix your policies. And then we'd generally finish up with a victim's advocate, somebody who'd lost a child or a husband due to distracted driving. And it was just a really nasty 1, 2, 3 punch. And we found, particularly through the National Safety Council seminars, and these were all free industry pro bono, that we got a lot of major companies changing policies. We all talk about positive change as plaintiffs lawyers. We all preach that. Generally, a lot of us preach that as long as it puts dollars in our pockets. But in reality, I think we really did create positive change. We'll never know how many lives were saved as a result of those speeches. And I'm not doing it just to break my arm, pat myself on the back. There were a lot of other people that went to that. We all just realized it was a danger and we needed to preach about it.
It's important to get the thought process out there, the understanding of everything. But, let's talk a little bit about nuts and bolts when it comes to, well, I will call it distracted driving. I think actually at your TTLA CLE, which is the reason why I asked you to come on, because I was like, oh man, like I have been missing this on cases. It's in my request for production. They object to it, especially recently with I wouldn't say super recent, but Enrique Curry decision. Should I fight for this? Do I even know if they were on the phone? Let me move on, right? But when you did that TTLA CLE, I was like, no, I got to push this. I've got to push this. And I'll tell you how it's helped me on some of my cases. But in that CLE, you said the distracted while driving is the new DUI. Can you talk a little bit more about that?
The original title of this thing was DWD, while distracted, the new DWI. And it's from other people, and I will I usually steal from others very liberally. This is one that I actually invented. The reason why is, let's think about it this way. You're a young guy, so this doesn't resonate with you like it does with my average audience that, is 40s and 50s and 60s. But regardless, I'll say, when you were young and you saw somebody driving like a damn fool, what was the first thing you thought? And when we were young, the thing was, well, they must be drunk. Let's call the cops. We didn't have a cell phone to call the cops on, but that was the thought. Let's call the cops. Today, you ask any juror, and this is actually a voir dire question that I occasionally ask, if I don't necessarily have clear proof of cell phone use, I will say, when you see somebody driving like a damn fool, what's the first thing that enters your mind? And 90% of them will say, get off your phone. They're on the phone. And that is something that we planted in our jurors' head, that is the single biggest worry. That's the single biggest danger they face on the roadway, but for both them and their families. And of course, that is reptile, now edge, peanut butter. That is exactly what you use to motivate a jury, because they want to send a message to everyone that they shouldn't use the phone while driving. Of course, while they themselves want to continue to do so. That particular thing is the one thing that jurors will simply, there's a disconnect. They want to continue to do it themselves, but they want everybody else to stop because they know that is the biggest threat to their lives while driving.
It's interesting. So I went to your CLE. I did some research. They had this, I think it's NHTSA said, distracted driving is a distracted driver is 4 times more likely to cause a collision. At least they did that study in 2021. They have a 2-second more reaction time. And they said something crazy. It was like, I think, I don't know if it was NHTSA or TxDOT, one of the two said 1 in 5 accidents is caused by someone using the cell phone. They didn't say distracted driver. They said someone using the cell phone.
Very underreported. There is no breathalyzer for distracted driving, and so it's very underreported. And people now know that when they do it and they get in an accident, they're going to try to cover it up like a dog trying to cover up a turd, and so they're not going to honestly say so. The numbers are really overwhelming. The coolest study, and this is a study I will talk about in every speech that I will ever do, dates all the way back to the late, like 2008, 2009. My buddy Dave Strayer at the University of Utah was the pioneer in this area. And he has a really cool simulator there at the University of Utah. It's not just a video game. It's literally a car completely constructed around. You feel like you're going over a railroad track. You feel turns. It's everything. So it's a real car driving experience. And so what he managed to do was he got his group of people, 50, whatever it was, and they went through and they did the errors in driving, and they counted the errors in driving. And then he got them drunk to 0.08. They counted the errors when driving. And there was a gap each time because otherwise you learn the video game. So there was a gap in space. Then they brought him back again and somehow got them all literally blowing into a breathalyzer with vodka at 0.08, ran them through the simulator. The error margin, it was the same at 0.08 as it was for driving with the cell phone, either handheld or hands-free. And so that's the beauty, and it makes for an incredibly simple argument. Now, you got to have an expert to bring it out, but it's to say that driving while distracted, driving while using your cell phone is the same as legally driving drunk. And, we all know that 0.08 is not a magic number. There's plenty of folks that have driven 0.08 without any real consequence. That's why we don't have a million wrecks on the road today with cell phone use. But it still quantifies the risk, and the risk is really serious, and it makes for a really great jury argument.
It's a great argument. It's kind of, you have the same reaction time on the way to happy hour texting your friends that I'm on the way than you do as the same as when you're leaving the happy hour and you've drank too much. That's a crazy way to think of it.
Companies say, we've got to use our cell phone as part of our business. Well, then you make the argument of, well, what if it was part of the business that you wanted your drivers have to drink 4 beers? Because that's about what it takes to get 0.08. Would any jury tolerate that? Hell no, they're not about to. And so it abnormalizes what is to a jury perhaps normal behavior. And you've got to get them that way, because otherwise, it's just stunning. We all expected a jury to go, no big deal, I do it myself. That's just not the case. And of course, more importantly, insurers don't perceive that's the case.
Let's talk a little bit about like nuts and bolts of this. So, I've had a case I thought definitely was some cell phone use. They had the policy and to back it, had the damages to back it. So I filed, as soon as I got the case, I got a TRO in place, got the cell phone, got a cell phone download, paid, I forgot how much it was now. Let's just say 15 grand. And we're off to the races in it, right?
Okay.
2 things there. That is a lot of work within a few days. Second, money for a case that obviously, with what I'm trying to get for, fair, but on any 50, 100, 30, 60, 100 even, the numbers aren't going to add up for that. I can go to a client and say, I proved that they were on the cell phone, but you're not getting any money. That's not good lawyering. What do people do to try to get this information without having to go through all of that?
You do not need to do the full download and all that in every case. You would only do that if you had the case, a great commercial case with serious injuries or death. And I would do that in a heartbeat. And I have done it many times in a heartbeat. But in a regular case, just a regular car wreck, first thing I do, start out with discovery request. were you on the phone in the 5 minutes before? Or actually, I think I'd go 30 minutes, 30 or 10. I can't remember what my discovery says. Let's say 10. I think that's safe. Supreme Court case. Were you on the phone in the 10 minutes before or after? They lie or they just object. Okay, that's fine. I have two routes to go at that point. First route is that I can go ahead and do a DWQ of their phone provider. If they don't provide me that information, who the phone is, then that's obviously a motion to compel. But I've got a pretty cool trick, and it worked beautifully a month and a half, 2 months ago. I was deposing a TCU student whose family literally owned the United supermarket chain. They might have a little money, and they might have been insured by Chubb. And it was a rear end collision, and this young girl was a train wreck. The more I got into the depot, the more I found she had started out in Fort Worth and had gone to boarding school out east. And you could just tell there were all sorts of problems, red flags. And I said, ma'am, I want you to know I'm going to request your cell phone records, and I want you to know about the penalty of perjury. If you lie under oath, if you do not tell the truth, you committed a crime called perjury. And that is actually a criminal offense. That's not just a civil offense. So I want you to understand what perjury is. Do you understand that, ma'am? Yes. Now, I'm going to ask you a very important question. In the 5 minutes prior to this crash, were you interacting with your cell phone in any way, shape, or form? Well, I'm not sure. I may have. Oh boy. And that just opened it up. Come to find out, she was in a fight with her boyfriend when she rear-ended my client. And she had literally lied, saying my client had done a quick stop as she entered an intersection to try to stage an accident. And now she's in a position where she's had to admit that she was on her cell phone more likely. And she still waffled a little bit, but no jury's ever going to believe if she said I may have, that she wasn't on it. And she knew damn good well she was.
Right.
And so the case doubled in value that day. It mediated about 3 or 4 weeks later, and it settled very well. And and so you don't have to do all the bells and whistles. Now, would I have immediately gone and done a DWQ? Absolutely. Can you pull out the DWQs? You got to do a lot of crazy things with the DWQs because sometimes they're on a different global time and you got to run it back to your time. There's all sorts of nuts and bolts you have to do, but you don't have to have
the UTC.
Yes.
Or I think it's UTC. Yeah. I always get confused with it.
But you really also, if you've got a case that's got good value, and I would say, obviously $500,000 or better, then go ahead and hire Paul Atchley out of the University of Florida or Central Florida, or Dave Strayer out of Utah. Those guys are the bomb. They are the best in the country. They cannot be touched on .air because they do not say that the crash was caused by DWD. They say the circumstances of the crash are consistent with the dangers of DWD. And they're not going to run you big money. Nothing like what we all see with the experts. I'm not going to price them here on this. That wouldn't be fair to them. But I'm saying
sure,
they're surprisingly reasonable when you consider what it costs these days for the best of the best experts. And they're always worthwhile because the defense lawyers can't lay a glove on them. They just can't because they go both defense and plaintiffs. If your plaintiff's on the phone and there's a contrib, they don't mind at all saying it's the plaintiff's fault or that the plaintiff's behavior is consistent with DWD. So they're not your typical, plaintiff-only experts.
Right. I took on a case. It was a small case. I mean, I'm talking like Cairo only. As a lot of viewers know, I just started my own law firm, so you don't get to always get the pick of the litter when you start off. The only thing the guy had was that the defendant was on cell phone because at the scene he happened to have video, and the defendant was like, "Hey, I was on the cell phone."
Oh wow!
Obviously, insurance company gets involved, and no, none of this is true, none of that.
Yeah, right.
So I didn't even do the deposition yet. What I did is I took the records from the NHTSA, filed a motion to take judicial notice of cell phone use, just letting them know from the get-go, this is what my case is going to be about. And we didn't get to depots. I mean, I think I settled the case it was a 30-60. I think I got the policy. But on a Tyra only case with, less than 10 grand in meds, I mean, why not? Right. But you have to create value with what you can do. So there's a lot of ways, and you really brought it home. I mean, there's so many ways that you can bring this in. And I think most of us out there are missing it. I know I was until I saw your CLE. I was like, it's an afterthought. If I can get there, that's great. But I've got 200X cases. I don't know if I can get there. But if certain small things like that to move the case, do it. Right?
Yeah.
I mean, I don't see any reason why you wouldn't do it.
And if you got a try case, and I have yet to ever have to do this, but I came up with this one night, and I just thought it was the coolest closing argument that you could ever do. Even if you don't have a cell phone involved or you can't prove it, if it's a rear end collision case, on your final closing, you can say, I think, without any chance of an objection, I think we all have a pretty good idea why this crash most likely happened. And then just move on.
Can I do that while I'm on the cell phone in the closing?
No, but I just think that every one of the jury is going to fill in that freaking blank. They're going to fill it in. And they're going to believe that they were looking down at their cell phone. Sure, you couldn't prove that they were necessarily, doing something with it. But I think that is a absolutely genius way of getting something in. Years and years ago, in one of my first truck wrecks, I had a trucker that was regularly ticketed, but he went through and got them all dismissed. Well, when the local highway patrolman, I called him to the stand, and and it was all limited out. Obviously, all those tickets were limited out because they weren't convictions. But when the local highway patrolman I called to the stand, I said, "Did you know Mr. Glover before this particular accident?" "Oh, yeah, I knew Mr. Glover very well." And we just moved on. And in the aftermath, the defense lawyer came up to me and said, "You son of a bitch. Everyone in that courtroom knew exactly why that trooper knew that trucker very well." And that's the exact same way. You have to do it. Let the jury fill in the blanks.
Yeah, absolutely. You have to trust the jury a lot of times, right?
Sure.
And hope that they catch on. It doesn't always have to be that apparent. Although some attorneys may disagree with me on that one, but that's okay.
Sure.
Talk to me about one of the bigger cases you've worked on with distracted driving and how you really implemented that throughout the case.
So we had a incredibly cool case like 3 years ago. It was at the very beginning of COVID, and it was on the very end of March. Well, I'm sorry, this end of April, right at this time. And we had a young man who was going stir crazy at his home with his common law wife and her 3 children. And he called his mom and said, "Hey, Mom, can I come over and drive a motorcycle and see you?" And the mom said, "Sure, I'll put lawn chairs out in the front yard and we'll talk." Remember that time where we literally couldn't talk to our parents except outside in lawn chairs. It just seems so strange, but that's the time we were living in then. He was on his way to his mother's. It was about a 30-minute bike ride, and a cement mixer turned right in front of him into their facility, and he hit it like a bug on a windshield. There was thankfully a driver cam that caught it. And the driver cam, it was very clear the driver was on his cell phone talking, and it was hands-free. And literally never saw our guy, never saw him, looked and did not see. And that's one of the characteristics, by the way, of driving while distracted. It's called inattention blindness. Literally, our brains are overwhelmed with our conversation, and we look and don't see because we're not expecting to see a motorcycle driver. So our young man was killed. There is no difference in the crash risk between hands-free and handheld. That is a terrible misconception. And let me explain why. And then let me tell you why, because you're going to run the exact same conclusion. When you are drinking a cup of coffee, just like I am right here, I've drank it. I hadn't had my coffee this morning. I got to get my cup of coffee in. When you're driving down the road and you've got your cup of coffee in your hand, does that make you an unsafe driver necessarily? Yeah, probably you should be at 10 and 2. But the reality is this is not the distraction. It's not. When I grew up, we all had manual transmissions. My first cool car was a Nissan Maxima with a standard transmission. I wanted it because it was the 4-door sports car. And that lasted about 2 years in Dallas traffic before I decided I didn't want no more manual transmission. But we spent our whole lives with this hand on a stick as we went through traffic. So this phone right here is not your distraction. It's not. But people think it is,
Right.
because this hand is not the problem. It's this. It's his brain. And we know that there's all sorts of different kinds of cognitive distractions. For instance, people say, well, what about radio? No, not at all. Radio is this passive thing that we just kind of consume, that even if we're singing and having fun, that's really not affecting our ability to drive. There's hundreds of studies that said that's fine. Well, what about a passenger? Isn't that the same as when I'm talking on a cell phone? Not at all. Your passenger becomes a co-pilot, particularly if I'm constantly telling me I'm about to screw up, stop, that kind of thing. So your passenger becomes a co-pilot, and when the driving task becomes difficult, when it becomes stop and go, all that, your passenger is going to moderate their conversation with you because of the driving environment, because they don't want to get killed. So that's not the same. But the problem is when we are involved in a discussion with an adjuster and they're telling us our clerk, and we are sitting there citing the 23 reasons why in our demand letter we said they were, and we're pissed off and everything else, I am in no more paying attention to what's going on the road. It is autopilot. Now, autopilot works really, really well, because the converse, you're going to come back to me and says, well, if autopilot means we all get in accidents, there should be literally, it should look like, the Road Warrior. It should escape on our highways. It doesn't. People go in autopilot just fine. But the problem is when something unexpected happens, when somebody swerves into your lane, when a motorcycle's there that you don't expect to be there, whatever, your brain does not process that that's there. They will literally say, and this guy in this, he filled out his accident report. He said, the fact is I never saw him. And that was damn right. He saw him. There's no chance. You can watch his facial expression until he bounced off his truck, even though he was looking down the road, he never saw him. So obviously we turned this into a monstrous distracted driving case, because why? They had a policy against cell phone use completely. But what was it? It was a paper policy. They didn't enforce it at all. And in fact, we were able to get because through the court, we got a very wide range of his cell phone records back 3 months. And we got him 3 months because we were going to show a pattern of practice of distracted driving. We compared those cell phone records to his logs, to his electronic data logs. And so we were able to prove when he was on his phone, when he was driving. And we established that over 150 times in 3 months, he was driving while on his phone in his truck. Moreover, the buddy he was talking to at the time, they had been talking for 45 minutes. He had a phone buddy who was also a cement truck driver for the same company. They had talked over 100 times, and they would talk 20, 30, 40 minutes. That was just their de facto. Instead of listening to the radio, they call and shoot the shit. More importantly, so we established all this. Then this guy said that he walked around with this collar. It was a Bluetooth collar around his neck all the time at the yard and everything else. It was a Bluetooth speaker. He was showing his bosses every single day that he was flouting the rules. His bosses admitted they knew what that was, and they didn't do one damn thing about it, ever. Imagine we started asking people at the company, what have you ever done? And then they also had lytics, which showed coaching events for cell phone use also. I don't know if you know about that for driver cam, but these are the driver cams where, okay, so most of these companies now, a lot of major trucking companies have driver cams, and they show both the driver and they shoot both ways, the driver and the employee.
Mm-hmm.
And when there's an event that happens, it will show 10 seconds before and 10 seconds after the event. So you can know what's going on. Well, these things are triggered by dozens of things, like going over a railroad track could be like going over a rumble strip or whatever. So it goes to Lytix in San Diego, and probably Lytix farms it out somewhere. And they come back and they send back codes to the trucking company to show what they were doing wrong, following too closely. If it's a quick braking event, quick swerve, whatever. Well, in those use cell phone use. And the question then is, what have you done as a company to enforce your policies? And most of the time, the answer is nothing, because most of the time, 3 guesses who requires the driver cam. Guess who, Michael? Who do you think requires?
Insurance companies?
Absolutely. It's an insurance company thing, because they know Big Brother is that if you have a Big Brother who's watching you, people drive more carefully. And so, but the companies don't buy in on it because they don't give a shit, because that they're supposed to coach bad behavior. The whole theory behind a driver cam is not, we want to know, it's not a black box to know what happened at the crash. The whole theory behind driver cam is we want to find bad drivers doing bad things, and we want to either coach them or fire them before they cause a bad crash. And companies don't use them for that purpose. So our client was in his late 20s. He was very, very close to his parents. His parents were devastated. His loss. His mother considered suicide. It was truly a life. They'd been together 7-8 years. He treated her kids like his kids. It was a very good damages case, but it was mostly an incredible liability case. And the case resolved. And it resolved because of some really, really bad facts.
And those bad facts, I'm assuming, were not absolutely apparent. I'm sure you got the dash cam, you show him probably talking on the phone, but to get the background, create a habit, I mean, that required a lot of work to prove up.
Most people, I'm going to break my arm and pat myself on the back, most people would have just gone with what they had. And they would have gone and they would have called Paul. Actually, I think that's pretty well known now. Go call an expert, have him testify that this is consistent. But it was like, oh, hell no. This is just the tip of the iceberg. This guy is not just doing this one time. And once we found out that they had a policy, because that's the problem, they didn't even bother to get an expert to say hands-free is safe, because they had their own policy that they were violating. And the reason why they didn't do the hands-free is safe is there's one group that does this, and it is Virginia Tech. Virginia Tech is owned by the industry, and they do studies to basically help the industry. And the last time I deposed a Virginia Tech PhD, he wasn't deposed again for 6 or 7 years because he just got killed. You cannot say this is safe to do.
It's interesting. I think this is it's going to require more work on any plaintiff attorney to do it. But I think today you've given us some ways to do it where it won't require that much work, one. And two, if the case is merited with it, now you kind of understand what you should do, right? So no, I appreciate it. While I have you, and as someone who's 7 months into his new practice, and is living a life day by day, essentially. I've been really blessed so far, honestly. Any tips for going off on your own?
I can. And I had one that I gave a bunch of Dallas lawyers. I'm not going to bore you with that. I'm going to tell you stuff doing right. Number one, you're on the TTLA listserv, and I assume ATLA as well, on a regular basis, asking for help, using it as a resource. I would say that's the number one thing for a sole practitioner to do. The number two is, developing a network. And I know you do that. And that segues into number three, be a good ethical lawyer. Don't take shortcuts. All the big boys that buy all this advertising, that buy all this internet stuff and all that stuff, they cannot duplicate what you can do with one happy client. We talked about this a little bit more, which is to take on more than you can chew. If you've got a really huge case, go into a joint venture with a lawyer that has the resources, that has your same ethics, that cares about the clients as much as you, and that's damn good at it. You smile, and rather than the typical sole proprietor that I talked to that's 9 months into it, that basically looks like they've got the world on your shoulders, you smiled and said, greatest thing I've ever done. So it's just been really good for you. What did you do right to be where you are today?
Oh, man. Usually I'm interviewing people, so I'm not always well prepared to answer, but I'll tell you a few things. Yeah, I know. It's a few things. One is I knew at one point that the only way in this business, I think your partner's very lucky, but the only way to kind of rise up the ranks and make, and not so much the money, but the way you want to do cases, right? Without someone saying, oh, I don't, either I don't want to spend money on this, or I don't want to do that, or you are in control, is to run your own and make your own mistakes, right?
Sure.
And I'm okay with making my own mistakes. I am. I'm not okay with, making a mistake because someone didn't, unleash me on something, right? So that was kind of a push for me. Not to say that anything was like that with my last law firm. It wasn't, but I just was like, let me go to the next level. Because at some point, you got to decide what you want to do with your career.
Yeah. You're either going to be an employee or an owner.
That's right. And so, that was important to me. So what I started doing is, at my last law firm, a lot of the referring attorneys really liked me, thought I got good results, thought I did them pretty fast, kept doing that. I kept doing that as an associate. I'll be very honest. I'm very honest with anyone about anything. I didn't have an agreement where I would get some sort of percentage or anything on cases. I had a salary and that's it. The idea was do good work on someone else's dime and do things that are going to be a little bit more risky so I can learn them, right? Like, as I gave you an example of doing judicial notice, stuff like that, like pushing cases in different ways, trying to be as creative as possible. Feel like I have a foundation, because my understanding in there was that the business stuff is going to be tough to learn by itself. So don't be trying to learn how to litigate or be a lawyer and the business.
Yeah,
like
that makes sense.
Get one at least somewhat down. So that's kind of the thought. A lot of attorneys, the second I left, reached out to me and said, "Are you doing litigation?" I said, "Yeah, I am. That's primarily what I'm going to do. That's all. That's what I'd like to do. Pre-lit's cool. I think it is good money. Don't get me wrong, all that, but it's not where my heart is. So that's what I'm doing." And they said, "We want to give you our lit work. We'll give you a few, see how you do." I turned them up pretty quickly. They sent me more. So I can't say I'm in a position where I'm begging for cases. And I think that's at good. 7-8 months out.
Oh man,
that's really good. Yeah, I cannot complain. I can't.
Yeah, you're not taking drugs, because one of my other things is as a shitty case lawyer. Because if you're known as a shitty case lawyer, it's really hard to get out of that reputation. And, I will literally, whether it was that one I told you about earlier, or even now, many others, ever a case for cost of defense. And even if it's a big case, like for instance, if it's a trucking case and I've got defendants that really aren't liable, they get cut loose. They don't pay $5,000.
Yeah.
And the reason is, when I've got you, I've got you. And when I don't, I don't. And it creates a ton of respect on the other side, because I get to make heroes as some defense lawyers from time to time, where they don't have to pay $5,000, $10,000 cost of defense, because I don't handle shitty cases. And you're doing the right thing, with litigation. Those are the hard cases. Now, I will tell you, I want you, hopefully in the next 5 years, to develop originations of cases, because pre-lit obviously is the easy way to make money. And we still settle better than 50% of our pre-lit cases. And I'm talking, I've got a case they're mediating on Monday that the demand's $9,975,000, and they asked us to go pre-lit, and they're agreeing to pay for the mediator all day, and they brought their first 3 towers of insurance. And it's not a very serious,
very rare.
Well, and the injury is a operated shoulder case, but there's some incredible bad facts, punitive facts. And so what I'm saying is, be sure you leave yourself, and I know you will, but leave yourself open for pre-lit.
Right.
Because lit, is hard, but the fact that you're doing great in it is a real tribute to your skills.
I appreciate that. I really do. A little plug for myself, since someone's asked me. I'm actually going on to a podcast next month to talk about getting engaged early on in litigation to try to get cases resolved relatively quickly. Because of a lot of cases I mediated, the mediator's like, this case is only 7 months old. How are you already resolving this for good money? So just a little plug. And I will send out stuff through my Instagram about that. But it's not about me on this one.
Well, it needs to be about you, because
it's
you're doing really good stuff with this kind of work. And one of my other plugs is you get a chance to talk. You get the chance to give speeches. I get early speeches to TTO. I first had success in the trucking arena, and the reality was I wasn't a trucking lawyer, but I did a 45-page case, everything else done in trucking. It was a Judy Coster level paper. It really was. I spent over 100 hours because, hell, I had time. I didn't have that much work. I rehearsed for hours and hours and hours and gave it at a TTLA. Thought something of me to a TTLA big program. Well, the speech was very well received. I still give a speech years later, and of course kept it updated and everything else. So what you're doing is you're availing yourself of all sorts of marketing abilities. And again, this is another one of the tips. You can't compete with the big boys on TV. You can't compete with them online.
No.
But what you can compete with them is with you and with personal relationships. And you do a great job of networking within Houston. That opportunity on that podcast, people are going to go, I never use these as self-promotion tools. I instead want to use these to let other people know how we did it. And if they like the way we did it, oftentimes they give us a phone call. But mostly I want to be sure that I give meat to people. I give nuggets so that ultimately they will know I'm a good lawyer. They know I'm a good person. They know I'm a giver. You do that really, really well.
No, I appreciate that. And, your time and compassion with TTLA has been, really significant. It's really helped all of us raise the bar on what we need to do on our cases. And you are, in my opinion, the gold standard on this, DWD situation. If there's anything that any attorney listening to this has a case like that or thinks they have a case like that, they should definitely give you contact, and I'll put your contact information in here as well too.
The funny thing is, you would be surprised, less than 5 referrals on that over the years, because everybody can do it. But I love to give people the information on how to do it right. I cannot tell you how many times I talk to people, give them the roadmap, they get there, they call me later. I had a lawyer in Utah this year send me a very nice bottle of Pappy. And he had settled a big case against FedEx involving distracted driving. And you know what? That whiskey drank really, really well. There was no problem with it. And so, that's probably the only payment I ask for free advice occasionally if you make a whole bunch of money off of it.
I'll keep that in mind. Todd, thank you so much for your time today. I really appreciate it. Any questions or anything like that from the viewers, I will put his email in the bottom here. And thank you guys so much for listening.
Absolutely. Thanks.